Hello, everyone, and welcome to USPTO Hour, the Trademarks Edition. It is April 23rd, 2025, and today we are going to be talking about trademark pendency and trademark register protection with a little bonus content about our IT systems. I'm Jason Lott, the managing attorney for Trademarks Customer Outreach, and it is my job to provide you with legal training in the field of trademarks. Whether you are a small business owner still working at the kitchen table, a garage inventor, a new lawyer, paralegal, support staff, or maybe you're one of our experienced practitioners with decades in the field, we want to make sure that you have the knowledge and tools that you need in order to accomplish your trademark goals. And specifically, we want to make sure that you are able to submit the highest quality application that you can. And of course, make sure you have the ability to avoid trademark scams. So as you can see on the screen, we have a full lineup of experts for you today, including the acting commissioner for trademarks and all three deputy commissioners. And I'm going to introduce them in just a moment. We're going to do it one at a time as we get to each of their sections in the deck. But before I do have a couple of quick housekeeping items. Today's session is being recorded. We're going to post it to the website as soon as we can. Oftentimes, it might take around 3 weeks. We'll see if we can speed that process up a little bit so you can have access to the content sooner. But typically, that's about when things will get posted. Slides are not available at the moment. They will be in the future. We will make sure that you can have access to those and be able to download those. If you are a person who wants or needs captions, you have two options today. If you're okay with robot captions, you can hit the CC button down in the bottom left-hand corner of your screen. But if you want live captions, you're going to find that in the chat box. If you want to open up the chat, it's down in the bottom right-hand corner. You'll see a little chat bubble. And that is where our tech team is going to be communicating with you today. So that's where you'll find the link to the live captions. And if you have a technical issue and you would like to have some technical help, please feel free to post that into the chat and our tech team is going to see it. Please be aware they are the only people who are going to be in the chat today. So if you're having a technical problem with WebEx and you hear music for some reason or something like that, hey, reach out to the folks and they will do their best to troubleshoot for you. If you have a substantive question or you want to quickly get a hold of one of the panelists today, the chat is not the way to do it. Our panelists are not going to be in the chat. They are not going to see it. If you do have a question that you would like to ask today, what we would request is that you use the Q&A box. Now, if you're looking at your screen and you're saying, Jason, I don't see a Q&A box, well, look in the bottom right-hand corner. You'll see three little dots. Go ahead and hit those dots. You'll see the Q&A box pop up. Now, please be aware, no one's going to be in the Q&A box today. We're not doing live Q&A while the presentation is going on. What we'd like to do is collect your questions as you post them today, and we're going to do our best to answer as many of them as we can next month when we do another session of USPTO Hour. So please feel free to pop your questions into the Q&A. Again, not going to be addressing them today. In the time that we have today to answer some questions at the very end, we're going to use the questions that were already submitted through the USPTO Hour at uspto.gov mailbox. We had a good number of those that came in, and several of them are going to spark some conversation, I am sure. So we're going to do our best to answer as many of those as we can before our time is up today. And so please, you can feel free to use the mailbox to submit your questions that you want to have answered next month, or you could simply pop them in the Q&A today, and we'll do our best to get to as many as we can. If you are a person who has submitted a question and it doesn't get answered, please, please, please don't take it personally. Over 1,300 people have registered for this event today. Not quite sure how many are going to show up, but I'm sure it's going to be in the multiple hundreds. And it's just frankly no way that we can respond to everyone's questions. But I promise you, we're gonna take a look at them and we're going to answer as many as we can and as broadly as we can, so you can have the answers that you're looking for. Okay, well, that is enough of our housekeeping. Let's go ahead and get to today's topics, if you could, Amando. So as you can see on the screen, it's a pretty light lift today. We only have 4 bullets. We're going to be talking first about the fiscal year 2025 priorities, and then we're going to dive deep into 3 of those priorities. We're going to talk about trademark pendency and quality, trademark register protection, and then we're going to talk about our trademark IT systems. So some of you who are a longtime users of the USPTO, you're aware that we've had some changes in our electronic and externally faced systems, and so you're going to hear a little about some of those things today. All right, so if you could, Amanda, let's go ahead and go to the next slide, and I'm going to introduce our first speaker today. And so Dan, oh, you already have your camera on. That's great. Okay, so this is Dan Vavanese. He is the Acting Commissioner for Trademarks at the USPTO, where he serves as the primary agency official for trademarks, domestically and internationally, and he is responsible for all aspects of the trademarks organization. Prior to becoming the acting commissioner, he served as the deputy commissioner for trademark operations, and in that capacity, he championed numerous initiatives to streamline and improve efficiency and examination, most notably the trademark pendency reduction plan, which resulted in a 2-month decrease in pendency in 2024. Pendency has been a problem for a while. We all know it, and so Dan was a primary driver in getting that 2-month drop. He first joined the USPTO as a trademark examining attorney back in 1995. Since then, he was promoted to management within the law offices, served as a senior attorney and then a managing attorney. He joined the executive team as a group director of the trademark law offices back in 2015. And he's also served as the business architect for trademarks, where he prioritized and planned updates to IT systems and business processes. And he received his Juris Doctor from the University of Baltimore School of Law and his Bachelor of Science in Biology from the State University of New York at Geneseo. Okay, Dan, over to you. I am going to get out of the way.
Thanks, Jason. Good afternoon to everyone, and thank you to all of our stakeholders in trademarks. I see we have well over 550 attendees so far, and it's still going up. So it's great to see such a big audience joining for our first USPTO hour focused on trademarks. For today, as Jason said, we are going to focus on 3 of our main priorities at a high level, and then in future USPTO hours, we'll adjust the content to focus on certain other issues that are of primary importance, especially to you as our main stakeholders. So I'm going to do just an introduction to our priorities now, and then I'm going to kick it over to Tom and Amy and Greg to talk about our more specifically the priorities. So as you look at this visual here, and for those of you who have attended TPAC in the past, this is a similar visual that you've seen. Our priorities are focused on, you start at the top with forge the path to 4.5. This is our pendency. This is focusing on lowering our pendency, lowering our inventory, with a goal to get back to 4.5 months by fiscal year 2027. So we have a 3-year plan to get to that point. We are currently at around 6 months. I don't want to get into the details because Tom will focus on that. But we have a 3-year plan to get to that 4.5 month first action pendency by FY27. Next, we talk about escalate the fight versus fraud. This is everything that you've heard about regarding our register protection efforts to protect the register against fraudulent applications, fraudulent actors that are coming in and trying to file fraudulent trademarks, also against fraudulent solicitations against our customers. This is a huge focus for our agency as a whole. Trademarks has been working on this for many years now, but this is a huge effort for us, and Amy will talk more about where our efforts are, how to look for scams specifically. Conquer the 7 summits by 2027. This is our IT efforts. This is all the work that we are doing across all of our IT systems to improve, modernize, improve the systems both internally for our employees as well as externally for our stakeholders. Greg will talk more about the 7 summits, but more about all of our IT efforts, because we've just had some big changes to our external systems through our trademark center and through our trademark search system, but we have a lot more going on our internal system modernization efforts. Elevate employee experience. This is all about continuing to improve the experience for our employees. Part of that starts with the IT efforts that we've already talked about, but it's also providing the resources and the systems to our employees so they can do their jobs efficiently, do their jobs at a high quality effort, and continue to provide them everything they need to be able to do a good job with the work they're in their work every day. The middle bubble, this is kind of the overarching, effort. This is to continue to drive high quality work. We want that registration symbol to really mean something. We want to produce high quality trademarks so that our customers can rely on, that our stakeholders can rely on, and know, hey, that means something. That has a strong protection for you when you need it, whether it's for customs, whether it's at the border, whether it's going into court with that registration certificate in hand. So this is quality all across the board, both in the applications that are coming in and in the registrations that we are issuing. We have one more priority that we'll talk about probably more starting next month. It's to simplify our processes. We'll talk more about that in the coming months as far as another focus of ours, overarching and with our systems. So I'm going to, that's the overview of our priorities, but then I'm going to kick it back to Jason, and he's going to introduce our other speakers to focus more on our pendency, our IT, and on our fight against the fraud. So back to Jason.
All right. Well, thank you very much, Dan. And Amanda, you can go ahead and advance to the next slide there. So it is my pleasure to introduce you to Tom Volchek. Tom is the Acting Deputy Commissioner for Trademark Operations, and in this role, he oversees the pre-examination, Madrid processing, examination support, intent to use and post-registration units, as well as the law offices for the examining attorneys. He joined the USPTO in 1990 as a trademark examining attorney, and then he became a supervisory senior attorney, then a law office managing attorney. He was a staff attorney in the office of the undersecretary, and in 2010, he became a group director of trademark law offices. And during his many years in this organization, he's been involved with a wide range of activities, from the development of procedures for examination of single color trademarks, to negotiating labor agreements, to developing systems for monitoring, measuring, and predicting trademark organization performance. He received a Bachelor of Arts from the University of North Carolina at Chapel Hill and a Juris Doctor from the University of North Carolina School of Law. All right, Tom, it is over to you. I'm going to get out of the way.
Great. Thank you very much, Jason. We can go to the next slide. I'm going to talk a lot about numbers here and our progress towards meeting our goals. Here you can see our main operations goals for this year. We have two pendency goals. First action pendency is the measurement from when an application is filed until the examining attorney takes their first action on the case. Disposal pendency is the measure from the filing of the application until the examining attorney until they approve it for beyond approval for publication when it registers or a notice of allowance is issued or the examining attorney abandons the case. As you can see there, we have our goals: 6.7 months for first action, 13 months for disposal pendency. We also have a goal for the number of balanced disposals that we produce in a year. That is the examining attorney's measure of production. They get a BD every time they do a first action on a case. And when they do a disposal on the case, that's either approval for publication or abandonment of the case. So that's how we measure our production within operations. We're also measuring our quality in two measures. Our two main measures are first action compliance and final compliance. Those both look at substantive issues on cases, either done in the first action or when the case is either finally refused or approved for publication. And we are measuring whether the examining attorneys are making the correct decision as to registrability. And you can see our goals there. So let's go on to the next slide. Thanks. So Forge the Path to 4.5 is one of our trademark priorities. So we have been focusing a lot on lowering first action pendency. We got rather high after the pandemic and we had a filing surge, and we have been working it back down. We're doing that very well right now. And as we do that, the disposal pendency has been going down along with it. And we have been taking measures to get there through efficiencies in our process, doing more production. We've offered incentives to our examining attorneys, and we've done hiring as well. Okay, let's go to the next. This shows our filings. Clearly, this directly impacts our ability to meet our goals for pendency and dealing with our inventory of new cases awaiting to be examined. The blue bars show the monthly numbers of applications coming in. It varies a bit. It can be quite erratic, and you can see an example of that. January jumped way up. People were trying to beat the increase that we had coming. And February saw a big dip. People had already filed in January. They did not have to file a lot of things in February, but we're getting back to normal now. If you look at the red line, that shows a 12-month average of those monthly numbers, and it shows much more smoothly that we are in fact going up. It's not going up rapidly right now, but we have a fairly steady increase of about 6%. Let's go to the next slide. This one shows our inventory over the last 5 years. Inventory are the new applications that have come in and are waiting to be assigned to examining attorneys and have a first action issued. If you go back 5 years, we were fairly consistently in about 150,000 class range for inventory. We were able to keep it at that low level. That corresponded with us being at about 3 months first action pendency. Once the filing surge hit us in 2020 and 2021, we were outmatched for those coming in. We could not keep up with the increases, and the inventory just grew. It maxed out at about 550,000, and we did manage to turn the corner on it. We increased the amount of work being done. We brought in additional examining attorneys. But we needed to do more than just keep things steady. We needed to lower it back to a sustainable area. So that's when our pendency plan went into effect. We started that about 1.5 years ago, and we have managed to push it back down again. Right now, we are at about, as of mid-year, about 411,000 classes, so well off of the peak we had, and we do have a goal of 383,000 classes for this fiscal year. We are on the way to meeting that goal, so we're in good shape. But by FY27, to correspond with that 4.5 month first action pendency range, we are aiming for in the low 300,000s for our inventory. Okay, let's go to the next. In this slide, it's kind of complicated, but it shows our progress on pendency. Pendency had peaked after the filing surge. We were over 8 months on first actions and over 14 months on disposal pendency. You can see the measures here. The dotted blue line shows our goal for first action pendency. We've been trying to lower that each year, and we are meeting those goals. The dotted green line shows our goals for disposal pendency. Also been lowering them each year, and we'll lower them both each again next year. The solid blue and green lines show our official measures for both first action and disposal pendency. Those average every case, how long it took for them to have the first action or the disposal take place, every case for the entire year, which is why there's a big jump between years on those. We start afresh each October 1st, averaging those together. Now the dotted red and dotted gold lines there actually show isolated just each month's pendencies, and you can see more the direction things are going over the course of the year. You can see a very steady decline in both the first action and disposal pendencies. So we are very confident of the position we're in right now. We're meeting our current goals, and we think we're in excellent shape to meet our 4.5 goal by FY27. Next slide. And finally, these are our quality measures. Like I said before, this is really looking at whether the correct decision is being made by examining attorneys as to ultimate registrability. And we measure that both in the first action that they take and also in a final refusal or approval for publication. We have many other quality measures, however. These are not the only things we measure. We look at the quality of the writing and the evidence they put in and all the little issues, procedural issues within the case. So we do look at a lot of quality, but these are our main ones, and we are meeting both of those goals for this year. So that's what I have for today. Turn it back over to Jason.
Okay, well, thank you very much, Tom. Now, if you could, Amanda, go ahead and hit that next slide. Now we're going to obviously transition into talking about trademark register protection, which is a pretty complex topic and involves a whole lot of different things. So we're very fortunate to have with us Amy Cotton, who is going to be talking about all of this. She is the Deputy Commissioner for Trademark Examination Policy. And in this role, she oversees the Legal Policy Office, the Petitions Office, and ID Class, as well as the Trademark Assistance Center, the Office of Trademark Quality Review and Training, the Trademark Law Library, Customer Experience, and Trademark's Customer Outreach. So, as you might imagine, she's pretty busy. She joined the USPTO in 1998 as a trademark examining attorney. She moved to the Office of Policy and International Affairs in 2001, where for 18 years she served as the Senior Counsel for Trademarks, providing both domestic and international policy advice to the USPTO and U.S. government agencies, and technical assistance to global trademark offices. For nearly 20 years, she led the U.S. delegation to the World Intellectual Property Organization, commonly known as WIPO, on trademark matters, including negotiations to conclude the Singapore Treaty on the Law of Trademarks and the Geneva Act of the Lisbon Agreement on Appellations of Origin and Geographical Indications. Prior to joining the USPTO, she served as External Affairs Counsel at the American Intellectual Property Law Association, also known as AIPLA. She received her Juris Doctor from Indiana University Bloomington and her Bachelor of Arts from the University of Virginia. Okay, Amy, over to you. Let's hear about some trademark registration protection.
Absolutely. Good afternoon, everybody. We are focusing on, in this bubble, escalate the fraud, the fight against fraud. Don't escalate fraud, good Lord, no. But we have three main initiatives under this bucket: clear the inventory, spread the word, and increase efficiency. So we're going to go a little bit. Next slide. So certainly, you don't need a U.S. registration in order to claim protection for your trademark. All you need is use and the common law. So we know we need to add value to the system, to the trademark ecosystem. And we are keenly aware of that need of making sure that the registrations that we issue are accurate, reliable, and help you with your business. So our use-based register means that we have a register of marks that are actually in use, which is really important for businesses to increase business certainty. You know what's out there. You know the pitfalls of what you might face if you choose to use a particular mark in an industry sector. And so our use-based register helps you avoid those pitfalls. And of course, then it also reduces litigation. Overall, a trademark registration reduces the cost of ownership, and we want to continue to provide that service to you all. But over the last 5 years, we've really had to prioritize protecting the integrity and accuracy of the trademark register because we've seen a rise in scam activity targeting trademark customers. In 2020, we actually formalized the Trademark Register Protection Office to combat these threats, even though we'd been working on this for quite some time. So the RPO, Register Protection Office, has to figure out the scam in order to be able to combat it. So we talk to victims who contact us at tmscams@uspto.gov. We talk to online platforms, we talk to law enforcement and other agencies, and we look at filing data for trends to see what is happening behind the scenes. Next slide, please. So the two main scam activity that we're seeing, and these are big. There's two main types. The first one is the foreign trademark filing firm. So these foreign filing firms, they're filing, they're typically foreign agent filing firms. They're seeking access for their clients to e-commerce platforms, brand registries. So this could be Amazon or Taobao or whatever it may be. Many platforms started requiring US applications or registrations as early as 2015 as a condition for enrolling in a brand registry. And it was intended to be an anti-counterfeiting initiative. So the idea being that if you have a trademark registration, then presumably you are not a counterfeiter. Well, that meant that we got a lot more applications for those people wanting to sell on Amazon because it got them, or Taobao or wherever, because it got them additional tools as a part of the seller platform. But so subsequently, though, we began noticing an increase of suspicious filings, originally emanating from China, but we've seen some others as well, starting in about 2017, 2018. Originally, they contained digitally altered specimens of use. That was where we saw the suspicion, the fraud happening. But over time, we've actually been able to identify a lot of other data markers from these foreign filing firms beyond just the specimens. They've gotten actually better and better at filing specimens that look real. And therefore, then we noticed that there's other markers that we can use. The fake attorney credentials, fake addresses, fake signatures. All of these rule violations invalidate the applications and any resulting registrations. So we're going to talk about that a little bit more. But the second scam, let's look at that one. This is actually a foreign criminal syndicate. This is what the FBI tells us. One of the largest global criminal syndicates. They create hundreds of low-cost filing or logo design websites to entice the business of novice filers. They gradually increase the pressure to add on unnecessary services and fees. They spend a lot of money for sponsored ads so that their sites come up first when folks are searching for trademark services. They show up higher in the search results than USPTO. Once they file for the trademark application for the applicant, they use their own email address as the correspondence address so they can intercept all of our communications. They use spoofed USPTO emails, spoofed phone numbers, mocked up US communications from the USPTO. They inflate fees, they include unnecessary services, they force victims to pay through a fake USPTO payment portal. We may never see an application from the applicant, but the applicant wouldn't know that unless they knew how to check TSDR and the like to see if an application was actually filed. Next slide, please. So what have we been doing about it? Two main buckets that we want to talk about here briefly: prevent abuses and punish abusers, which of course then deters the abusers in the first place if we're doing it well. We want to educate our customers about scams. We want to partner with other agencies and law enforcement to prevent victimization. The more people who know about what's happening, the less likely they're going to get scammed. So that's been a huge focus for us. We've increased the security of our filing system. You all have experienced this with ID verified USPTO.gov accounts in order to make submissions. We're actually, beefing up even more with multi-factor authentication and that sort of thing. We have to lock down the filing system so we know who we're dealing with. As you know, we've required U.S. licensed attorneys for foreign domiciled applicants and registrants. That's the idea, is putting somebody in the middle that's on the hook for the accuracy of the filing coming in from the foreign applicants. And this is for court jurisdiction, right? If you're a U.S. domiciled applicant, we do have jurisdiction, our courts have jurisdiction over you, but if you're a foreign applicant, it's harder to get that jurisdiction. So if we have somebody on the hook for the accuracy of the submission, that's important. Flipping over to punishing abusers. What are we doing? We're identifying and removing suspicious applications with suspected rule violations from an examination. We're referring them for administrative review by the Register Protection Office. We're imposing discipline on U.S. attorneys who circumvent the USPTO rules on behalf of the foreign applicants and through working with the USPTO's Office of Enrollment and Discipline. So these are the U.S. attorneys who contract with these foreign filing firms. They do not review the submissions. They rent out their credentials, and they're not following the rules of professional conduct, nor are they making sure that the rules of practice are followed for practice before the office. We issue sanctions where we're terminating applications and registrations where we've determined them to be invalid. Rule violations invalidate the submissions. And so therefore we have to prove the rule violations in order to invalidate the submissions through our sanctions process. And then we remove those from the register so they're no longer blocking good faith applicants. We also initiate non-use proceedings and audits against scam registration. So this would be the Trademark Modernization Act proceedings. This would be the post-registration audits. Next slide. So that's what we're already doing. What are our priorities, moving forward? What's next for us? We need IT, we need automation so we can do all this stuff faster. So for the past 5 years, we've had to create policies and procedures and Excel spreadsheets and everything manual to try to deal with these suspicious filings coming in and try to figure out what do we do with them. We were originally, presuming good faith by applicants. We can no longer presume good faith by applicants. So that we kind of had to change our business model. And you may know that if you were at the USPTO hour for patents last week, patents is a few steps behind us, but they're forming a fraud mitigation office as well. We're about 5 years ahead of them on this, but of course we've paved the way and made everything a lot easier for them, and they'll go a lot faster because we've created the culture of looking for suspicious filings, mitigating those filings, and getting them out of the way of the good faith applicants. We need a docket system. We need automated workflow to make this stuff go faster. Our priority is to clear the inventory. I think there's some questions about what this suspicious application is being held. It's blocking my filing. Yeah, it's going to be blocking your filing until we can invalidate it, until we can initiate the sanctions procedures that get it off the register. If it turns out when we look at it that it's not invalid, that there aren't real violations, that it was just swept up in the net, then we'll release it back to examination. But we have to go through that process in order to make sure that we are moving the things that need to be invalidated into the sanctions process. So again, I'm going to have to, as I've said in past presentations, you're going to have some patience. We're working to get these things through. Certainly, we have to, go through our sanctions process and provide the evidence, provide the due process to the registrants, to the respondents, and then move these things to disposition quickly. Spreading the word, again, social media, scam alerts, TM alerts, educating consumers about our rules, educating our customers about our rules. We'll probably talk in the future about our signature policy. We're also, of course, partnering with other agencies. There's a lot of government imposter scams are the #1 scam that we're seeing on the Federal Trade Commission dashboards about scam alerts. Social Security, IRS, all of these places are going through what we're going through. So we're partnering with them to try to figure out how do we warn customers that these things are happening. On efficiency, we are moving towards role-based access controls in Trademark Center. What does that mean? That means, you remember those user roles that we implemented in USPTO.gov accounts? Those user roles are going to set the permissions that you have going forward. So if you are an attorney user role, you will be able to touch the file where you are the attorney of record, but you will not be able to submit anything else other than that. If you're the owner, you can only touch the files that you are the owner. And that way, then we can prevent hijacking, which we'll talk about a little bit more. Efficiency, another piece of efficiency, more IT, a fraud algorithm that will automatically divert suspicious filings into our docket system. Right now, we are manually doing this based on our team looking at the filing data and looking at other pieces of information and putting it together. We have plenty to do without a fraud algorithm finding more, but of course that would make things a lot easier to spot these things and get them out of examination quickly so we do not waste any examination resources on these. And lastly, on efficiency, verifying attorney credentials for USPTO.accounts with an attorney user role. This is the move towards role-based access. We want to start looking at how to ensure, starting with the attorney role, that you are who you say you are, you have credentials, you're not, that you can only touch the files that you are the attorney of record for, or, that are in your circle of trust. And then, from that standpoint, we can make sure we know who we're dealing with. Next slide. So let's break these down a little bit more. Preventing abuse, scam awareness. We are educating customers. We're collecting scam information from victims. We're providing assistance and resources to victims. A lot of them want their money back, but that's not something we can do. That money probably didn't even come to us. It went to the scammers' pockets, and we've never even seen it. We work with other federal agencies. Certainly, we've been working with the Secret Service and the Federal Bureau of Investigation and the like, trying to raise awareness and get folks to focus on this. The Federal Trade Commission has been a great partner. Even the Better Business Bureau, we're working with them. We're working with online platforms, raising awareness, reporting instances of abuse, anything that we can do. We're also bringing domain name enforcement actions. A lot of these, particularly on that scam type 2, what we found is a lot of government imposters, trademarkassistancecenter.com. So we will take enforcement actions against those domain names where we can. So we have a bunch of different offices who are working on this. The Register Protection Office, my customer outreach office, our comms and marketing team work on this, and our solicitor's office and the Office of General Law all work on this. And there's one I just wanted to flag for you. We have been working on social media posts and videos and that sort of thing on scam awareness, trying to push those out. So I wanted to show you one of those that we have produced lately, so you know what we're up to. Can we roll that? So that's a little bit of what we're doing. I think the birds chirping are supposed to make you feel calm, even though all of that stuff is coming at you. Hopefully that helps. Next, I wanted to talk a little bit about the USPTO.gov accounts. We are really finding these helpful. We know who we're dealing with. When that account is being abused, we can shut it down, and that particular identification can't be used to create the same account over and over again. So that's been really helpful. And again, this will be the way that we can control the role-based access later on. So just so you know the process, so the user creates the USPTO.gov account, they claim their user role, they switch over to ID.me for the verification process, it comes back to us, and then we assign the user role for filing, and that gives the permissions. So in the case of attorney credentials, already you can provide attorney credentials at the USPTO.gov user role phase, but we're going to start validating those. We're going to check to make sure that those are real credentials, and we'll go to the various bar association websites to try to do that. I think there was a question about whether we check to see if somebody's credentials are good or not, and we're doing what everybody else is doing and go to the bar association website to check it there. Next slide. The sanctions program. So again, we're removing filings that have suspected rule violations from examination, so they don't sit, the examiners don't have to spend any time on that. They can spend time on the good faith applications. We review filing data and account behavior to figure out whether there was a widespread effort to circumvent our rules. We collect the evidence of those violations, terms of use violations. We issue show cause orders. We give the respondent the opportunity to respond, the applicants or the registrants opportunities to weigh in, and then we will move to sanctions if we need to against those those entities responsible. Now, again, those rule violations invalidate the applications and the registrations that are subject to it. Whether or not the applicant was aware of what their agent was doing doesn't matter. The acts of the agent are imputed to the applicants, to the registrants. That may be unfair, but the fact is these applications, as if they issue as registrations, are not worth the paper they're printed on. So they're not going to do anybody any good if they can immediately be blown up because they were invalidly filed. And it's not something correctable. It's not something you can paper over. It's that you need to start over if you are sucked into one of these sanctions programs. Sanction process, if you're under administrative review, cut bait, refile, start over without one of these, agents, foreign agents or U.S. counsel working with a foreign agent without them involved. Find a reputable U.S. counsel if you need one, or file it yourself and move forward that way. So again, the Register Protection Office folks, we're collecting information versus in our mailbox. We're looking at U.S. attorneys who are complicit, referring them to OED, reviewing filing data to identify these large-scale scams. OED will review the attorney misconduct and see if it is misconduct, and they will enter in a settlement or litigation with attorneys who have committed it. And then we take all of that from OED and we'll basically quarantine all the associated files and move forward with collecting evidence for sanctions orders. We will suspend accounts, we block credit cards, we misassign serial numbers. If we have evidence that the applications were filed with fraudulent credentials at the get-go, we will just misassign those applications. They will not get a serial number, they will not get a filing date. We will keep the fee, but we will not, you can refile again if you want to, but if we have evidence up front, we're not even going to let it enter the door. Next slide. Non-use cancellation. As you know, you have to submit periodic maintenance filings to maintain your registration, and it has to be in use by statute for all the goods and services in the registration when you file your maintenance filing. And if you include all of those goods and services in the maintenance filing, if you include goods and services that you're not using the mark for, that is false information that you're giving to the USPTO. We will figure that out. We will find out through our post-registration audit program. We will query and find out whether or not you're using in all the goods and services that you're relying on. We can also initiate director proceedings for non-use under the Trademark Modernization Act, and we cancel registrations where the registrant is unable to provide evidence of use of the challenged goods and services. So we've been doing a lot of work in the director-initiated space to go after specimen farms. Those are those websites that just have, pictures of goods that are purportedly for sale but aren't really, that foreign filings firms use to get a U.S. application in the door. That's their specimen of use. When you look at each one individually, it looks like it may be okay, but when you look at this in the aggregate on these specimen farm websites, you can tell that they were filed, that they're not really in use in commerce. So through the audit program and through the Trademark Modernization Act reexamination and expungement procedures, we can target registrations that are not in use. And hopefully that will deter those from filing, from maintaining registrations that they shouldn't be. Okay, and I think that is it for me. So I know there's some questions that have come in and we'll answer those at the end, but I want to kick it over to Jason and then he'll bring Greg back in.
Okay, sounds good. Thank you very much, Amy. And yes, some of the questions that were sent in previously touch on a lot of these topics. So I'm looking at the clock. We have 16 minutes left. So Greg, I'm not asking you to speed through the stuff, but we do want to have about maybe 5 minutes for questions at the end. So, folks, let's dive into it here. Greg is on the line. He's going to be talking about our trademark IT systems. He is the Deputy Commissioner for Trademark Administration, and his management responsibilities include oversight of the trademarks organization's IT capability, customer support, personnel, and financial planning. It also supports the commissioner's goal of building a cutting-edge end-to-end IT enterprise by providing analysis, innovation, development, management, and data quality. And his teams also focus on audiovisual creative support, website and filing system content, and performance planning and financial management. Prior to joining the USPTO, he worked for General Dynamics Information Technology, where he supported IT services to the U.S. Department of Defense. And before that, as you might guess by looking behind his right shoulder up high, he was a fighter pilot in the U.S. Air Force, holding commands in the United States and while deployed. He received a Bachelor of Science in Management Information Systems, a Master of Education in International Relations, and a Master of Science in National Resource Strategy. Greg, over to you.
Well, thank you, Jason. I just want to make sure there's a comm check. I am using my phone here today. Can you get, okay, great, awesome. All right, I know we've only got a few minutes, and so I'm going to blaze through the slides that I have. I just want everybody to know I feel like I'm the luckiest guy on this call because I get to bring it to the end, but I also am surrounded every day by a bunch of really, really smart intellectual property attorneys, and it's made me, the old caveman fighter pilot that I am, a much smarter human being. So anyway, it's been a great job. All right, next slide, please, if you would. And I think Dan has asked me to kind of cut to the to a few of these important slides. So we're going to do this. So this is our bubble. This is the IT bubble, conquer the 7 summits by 27. That number 27 is important because that also kind of coincides with what the agency is doing from an acceleration process to get to the cloud for the whole USPTO. Our IT goals are to build secure and resilient systems. Obviously, that's the foundation of everything that we want to do. Accelerate that migration to the cloud, which I'm going to talk about here in just a second. Intensify and continue modernization. Many of you know that we spent about the last 2.5 years working on the retirement of our TRAM system, the Trademark Reporting and Application Monitoring System, which is 42 years old. We finally got that done, and so now we're going to work on this other thing. And then something, and Amy alluded to this, but something very near and dear to my heart is to try to do the best that we can to integrate artificial intelligence, machine learning, large language models, those kind of things into the work we do under the basic premise that don't ask humans to do work that machines can do for them. So that's what we're going to try to do. All right, next slide, please. I borrowed this from the CIO. It's real important. It's kind of busy, but what it really does is it speaks to the idea of completing the circle for every one of the different projects and programs that we have in order to ultimately create a process of continuous improvement. So you see proactive there for operations and maintenance and technical debt. Everything surrounded by IT policy and security, target state architecture for high availability and disaster recovery measurements, and then ultimately security. And those dashed half circles complete the other circles and then kind of go all the way through the process over and over again. And that really kind of sets the tone for everything that we want to try to do from an IT perspective across the entire agency. Next slide, please. Sorry, I'm going a little bit fast, but I know we need to get to some questions. Here's the trademark product line in little branding kind of symbols, right? And, one of the things that's really important is to understand that what we have done is we've broken the overall TMPL, the trademark product line. Sometimes you might hear this referred to as Temple, into different capabilities that we can work on and have different people assigned to and bring to fruition. We've got external, we've got exam, we've got the content management system, which is really the database and the backbone of what we do. The TTAB, a critical partner in what we do, the Trademark Trial and Appeal Board, which is with us every step of the way, and then of course Trademark International, which is our connection really to the larger IP community outside of the United States. Next slide, please. This is just, I'll give you 5 seconds to read what's inside each one of the rectangles, but this kind of describes what TM External is. For most of you that are outside of the agency looking in at us right now, this is where you deal with us, right? This is Trademark Center. This is the old keys. This is your ability to do maintenance. This is where all this happens in Trademark External. Next slide, please. Trademark Exam. This is what our examining attorneys use. This is what our paralegals and our legal instrument examiners, all of the folks that do the really nuts and bolts, the blocking and tackling of the legal work that we do. It all happens within trademark examination. This is, it's a single suite. We're still working on it. Ultimately, the goal would be that you enter it on the very first day that the application drops to somebody who's going to look at it and goes through the entire process, to include money, which is important. Next slide, please. Content management, I mentioned this. This is our database, really, but this is really the backbone of what we do. This is the first place that we're striving to get everything into the cloud for integrity and resiliency and security, but this is really where everything is stored and everything works. Next slide, please. Trademark International, Amy mentioned this, 18 years working on the international side of the USPTO, but you know, this is all kind of defined by the Madrid Protocol and the work that we do with our international partners to make sure that our not really the systems, but the work that we do is connected to them. And you can see that on the slide. Next slide, please. The TTAB Center, obviously, if something happens and we don't get it right, the board gets a chance to take a look at it and decide what they think. So this is really important that we have a connection to them. Their systems from a security perspective are typically walled off from ours from a confidential perspective, and so we work very, very closely with them to make sure that we work to get their process squared away. Next slide, please. I guess that's it. All right, so let's see. We got 9 minutes, so I want to hurry up with this. Here's kind of in an order of priority. This is kind of what we're looking at. Getting to the cloud, obviously, because that's an agency priority. Getting enhancements to address fraud, and you saw that presentation just prior to this. It's a critical part of what we do, and we've not paid it the kind of due diligence that we have over the last couple of years. So we're going to redouble our efforts on that end. To get our retirement work done from TRAM, we've still got a bunch of work that we need to do there. Obviously, continuing to fix what we have and stabilizing the capabilities that we're developing right now. Trademark Center modernization, we've got a long way to go with that. As Amy said, we've got some work to do to bring some capabilities to the table in order to kind of lock down the opportunities that people have to fiddle with our systems and fiddle with the work that we do. Resume the modernization of Madrid. That's a tough one because we're in that with a bunch of partner countries, and everybody kind of both literally and figuratively speaks a different language when it comes to the modernization of the Madrid capability. But we're working on that. And then finally, of course, we want to do the TTAB that I talked about right there. And then underpinning all this is the artificial intelligence capability that we think is important. And I think one more slide for me. People ask what the, maybe not. Oh, there it is. There's the 7 Summit. So for those of you that remember fondly like we do, our prior commissioner who's since retired, he was a big outdoorsman, a big mountain climber, and this is kind of homage to Dave Gooder out there. As long as we continue to climb up our summits, we're gonna continue to make IT work really well for you and for all of our customers, both internal and external. And with that, I will go ahead and turn my telephone off, give it back to Jason to ask some questions of the board, of the panel. Thanks all.
Awesome. Well, thank you very much, Greg. That was great. And you moved very quickly through those. Thanks. Appreciate that. All right. So we have about 6 minutes left. And so we're going to dive into some of the questions that we received through the USPTO Hour at uspto.gov mailbox. Big thank you to those folks who sent those questions in advance. If any of you have been submitting anything through the Q&A today, please understand we're not looking at that stuff today. We're going to take a look at it over the next month, see what we can answer next month. But we do appreciate you sending that stuff in if you have been. So we have a couple of questions here we're going to try and hit. One of the first ones that we got was from Diana. And Diana is an attorney, and her firm occasionally receives requests from applicants who are clients of sanctioned attorneys, and those clients are now seeking some new representation. So Diana and her firm perform some reasonable background checks, and the applicants appear to be legit businesses, and their applications and registrations don't show any apparent deficiencies, but they are understandably cautious about proceeding in such cases, and they would like to have any guidance that we might be able to give them about what's the deal with assuming representation in these circumstances. Is that going to cause any problems for them and their law firm? Any reputational issues? Any procedural issues? Essentially, would a successor attorney or the newly appointed representative face any red flags or complications just due to the fact that the original filer was dealing with a sanctioned attorney?
That's mine. So there's two issues here. The easy answer to the question is no. The identity of the filer, the filer can refile with new counsel or pro se, however they want to do that. There is no there's no black mark against that particular the identity of the filer. What I would not recommend is taking over the application that has been sanctioned or terminated, or taking over, I mean, it hasn't been terminated, taking over the application and just trying to corrective action over everything that was done by, one of these rule violators. The application, if it's an administrative review, is probably gone. It's probably going to be held invalid through sanctions process. It's better to be refiled. But again, the filer can refile. We're not stopping that. We are keeping tabs on the attorneys who have been sanctioned. If they actually are reinstated and they come back in and they say they're not going to do it again, we do keep tabs on that to make sure we don't run into similar problems.
Okay, great, perfect. Hope that helps Diana. And the answer, Amy, actually leads really nicely into a question from Allison, who is wondering, she says thousands of applications are suspended for administrative review of suspected improper submissions. I know you mentioned those a little bit earlier today during your presentation. Some of those suspension notices issued in 2022, and the status remains the same today. And these applications are being cited as prior pending applications, which causes later filed applications to also be suspended, awaiting disposition of those earlier cases. So if you could, for as much as you can, what is the status of this administrative review of those cases that have suspected improper submissions?
As you saw in my presentation, it was our number one priority was to clear the inventory. Best laid plans. It still is a priority. It is still, we have a list of matters that we are working on getting to. But however, our best laid plans were thwarted while we had a couple of different crises come up. One crisis was the unauthorized car forms. We have continued to be fighting this constant battle with car forms, which are used to hijack applications and registrations. They come in through accounts, we shut down the accounts, they figure out another way to do it, and it just keeps happening. We had, they've moved from the car forms to other forms, and so we're constantly trying to build filters that stop these people from hijacking. So when an application or registration is hijacked in that way, a car form is filed, a notice goes out to the correspondence email addresses of record indicating that's happened. When somebody gets that who did not make those changes, they let us know, then we have to revert the record back to the original record, and we have to shut down the account where the unauthorized car form. It's a lot of manual steps, and these are coming in bulk. They're coming in singles. They're coming in over the weekend when we don't have somebody monitoring this. So it has been just a torrent. We are actually moving forward with a multi-factor authentication program for 6 of these forms that are commonly used to hijack. So you will be seeing communications from us on that as that rolls out. But we've gotten to the point where we are very concerned about malicious hijacking in bulk of registrations, and that make it very difficult for us to keep up with our manual processes. The other crisis that we had, which we had to deal with, were the hijacking of attorney credentials. There were a lot of California attorneys who don't do trademark law, whose names were being hijacked and put into files. They were filing applications with these names, and it just kept happening over and over again. So we had to try to put our finger in that dike and stop that from happening. And that's what we've been using that misassignment process for. We're getting declarations from these attorneys who've been hijacked, and then using that as a basis to misassign the applications where we can. So excuses, I realize that, but we've had a couple of things on fire, and that then has made it harder to move towards the sanction process to get the stuff that's been sitting for a long time out of the way. We did just issue a notice of reopening registration decisions to Seller Growth, a Chinese filing firm that covers 7,000 applications and 47,000 registrations. As we move forward with that process, those hopefully will get out of the way. We are working on that fraud type 2, the scam type 2. We have a whole bunch of applications that we've been sitting on that we're moving towards working on that ABTAC matter, which we issued a sanctions order on a couple of years ago. So again, I have to ask for your patience. We're working to get these things done. We know they're blocking you. We are fully aware of that, and we're working very hard to try to get those things out of the way while we're dealing with a couple of other dumpster fires at the same time.
Great. Thank you very much, Amy. And hopefully, Ken, that might also help answer your question, which was a data question about seeing some applications that all dating back several years that had not been assigned yet. Chances are it's probably because they are in that awaiting administrative review. That's why they haven't been assigned. Jennifer, you also had a question about that. How do you get it assigned to an examining attorney? It's been there for a while. Without any more specific data about which case you're actually talking about, it's kind of hard to answer that one, but chances are it might be one of those that is also stuck there in review for administrative review. All right, we are 1 minute after the hour, so we do need to get out of here. I'm sorry we couldn't get to you, Bernard. I think, though, Amy answered your question about are we using various tools at our disposal to help understand whether or not somebody actually is a legit attorney or not. Amy answered that one a little bit during the presentation. I'm sorry, Cheryl, we couldn't get to your question about delays in disposition of responses to office actions and things like that. Same with you, Denise. I'll see if I can get an answer for you. But actually, what Amy talked about was, actually, I know we're a minute over. Amy, could you just very quickly for Denise here, they have situations where the registrations were fraudulently transferred or assigned to another entity. And could you just very briefly maybe talk about what the course of action might be that they could take? Any practical tip you could give to Denise?
Assignment is another way that bad guys can hijack your stuff. And so certainly that is a concern. And we're also looking for ID verification and multi-factor authentication for the assignment branch. So that is something we're definitely taking a look at and hopefully moving forward quickly. For purposes of dealing with a fraudulent assignment, contact TM Scams at uspto.gov. They'll tell you what to do. They're going to ask you for a declaration saying that you didn't file that. And then they're going to ask you to paper over the fraudulent assignment with a new assignment. You also have the option of filing a petition to director. We will waive the fee, and you can, you can put a lot of things in the record saying that the assignment was fraudulent, but you don't have to file a petition. You can file the declaration and paper over the assignment.
And Jason, just to
please.
just to quickly address the pendency question, it was pendency and for office action responses and for statements of use. And for the office action responses, yes, last year we did have a delay of up to 4 months. We made several improvements to our processes, and we're currently below 2 weeks on processing of responses. On the statements of use, we're working down the pendency timeframes on that. That's at about 50 days right now. But we're working on some internal processes changes as well there. If you do have questions about a particular case, you can always reach out to your examining attorney if you find that these are outside of the timeframes that we post regularly on our website.
Excellent. Thank you very much, Dan. All right, folks. Thank you for your time. I know we're 3 minutes over and do apologize for that. We always want to be very respectful of your time and make sure that you can get back to your day. So thank you very much for being with us today. We do appreciate your time and your attendance and your questions, and we do look forward to answering as many of them as we can next month when we return for another Trademarks edition of USPTO Hour. So our agency is planning to give you an opportunity to meet all the various different USPTO business units. That's going to take place over the next couple of months, so make sure you keep an eye out for those notices. Make sure that you register or attend so you can learn all about the stuff that's happening here at the USPTO. Big thank you to Dan and Amy and Greg and Tom, and of course to our tech crew. Thank you very much for running the show today, and thank you folks for being with us today, and we look forward to seeing you next month. Take care.